Welcome back. I'm Derek Watkins from McKenzie Friend Consultants. In today's video, I will be covering how and when to make an effective financial offering in family court proceedings. Let me start by saying it's always far better if the parties can come to agreement themselves rather than the court deciding for you. Now, that is going to feel impossible right now. Let me assure you that having dealt with hundreds of financial cases in the family court, the vast majority of them, the parties do eventually come to agreement themselves. Now, many clients tell me that their exes are money-grabbing, unreasonable narcissists. And you may tell me the same. The reality is that there is little or no trust between the parties at the moment. And you're concerned that your ex is going to take you to the cleaners, leaving you with nothing moving forward, and little or no funds to house yourself and or your children. It's only natural to feel like this. It's a highly sensitive time. You want to protect your interests. You've contributed for many years, and you only want what is fair and reasonable. Now let me assure you of one thing. No matter how unreasonable your ex has been at the moment, as the proceedings move forward, at some stage, your ex will begin to be reasonable. When should you make your offer? Well, the answer is it depends. It depends on many factors. It depends on how reasonable your ex is being, and if your ex is represented. Now, you can make an offer at any time, including during mediation. You have to at least try mediation. And if things are progressing well, and your ex is being reasonable, then with the help and guidance of the mediator, it may be appropriate to make an offer during mediation. And it's far better if you can agree matters at mediation, and you can therefore avoid the family court proceedings. Now, for many people, that's not possible, and the only viable option forward is the family court proceedings. Now, during the proceedings, you can make an offer at any time, but you want to ensure that your offer is effective and will at least be taken seriously. Therefore, the timing and the nature of your offer made is highly important. Many people make offers very early in the proceedings in the hope to avoid going to the first hearing, which is not a bad idea, but it has two problems. Firstly, at this stage, your ex believes that you're hiding information and that you have far more funds than you're disclosing. Therefore, if you make an offer at this stage, they will just feel that you're trying a fast one. Secondly, what I experience is many people making totally unreasonable offers in the hope that their ex is desperate to avoid going to court. Now let me ask you this. Would you accept a totally unreasonable offer from your ex? The answer is no, and nor will your ex. And all this does is create further mistrust and resentment and makes life even more difficult moving forward. So my advice is do not make totally unreasonable offers, particularly at the beginning of proceedings. You will have to disclose your financial information at the beginning of proceedings. Therefore, I would highly recommend not to make any offers prior to that information being exchanged, because that is the beginning of the trust being built. But after many years of experience, my recommendations of when to make the best offer is either just before the second hearing, which is known as the FDR, which is the Financial Dispute Resolution hearing. Okay, because by that stage, you'd have been exchanging even greater details on your financial positions as ordered by the court. And the court will also direct you to exchange offers just prior to that hearing. So you have to do that. And by this stage, hopefully trust will have been built up because you are exchanging further details, and that's your cases. Now, if matters are not decided at that second hearing, it's also highly effective to make an offer between the second hearing and the final hearing. And the reason why is that at the second hearing, the judge would have given their indication of what the court believes is a fair and reasonable settlement. So you know roughly what the court's going to direct. So if you make an offer at or nearby what the judge has told you will be the outcome, there's a pretty high possibility that your offer is going to be accepted, or maybe a slight tweak to that. So what and how should you present an offer? Well, you should always present an offer in a letter. And your offer should be one that is fair and reasonable. And you should demonstrate in your letter how it meets the parties' needs and why it's fair and reasonable for both parties. Always put at the top of the letter, without prejudice, in capital letters. And it's also advisable to have an expiry date at which time the offer expires, but do be reasonable with that date. And my final tip, which I find tends to work quite well psychologically wise, is to have two options. The first option may not be as attractive as your second. Make it reasonable, but it may not be the one that they go for. And the second option is a more attractive offer, which you feel is reasonable and one that you would hope they accept. Well, that's it for today. If you'd like further assistance in making your offer or just help with your case, then go to my website, www.McKenzie Friend Consultants with an s.co.uk and book your free consultation with me. So, bye for now, and until the next time.